I am Kenneth Okonkwo, the foremost Nollywood actor, lawyer, and the spokesperson of the Labour Party Obidati Presidential Campaign Council.
Thank you very much, sir.
Thank you.
Okay, sir. Looking back to the just delivered September 6 judgments, about the presidential election petition court, the judgment is said to have raised eyebrows as to the way it was administered. We would like to take your reactions as to what you think about the judgment, and then going forward, knowing that your party has actually filed an appeal to the Supreme Court, to that regard.
You judge the veracity of a judgment based on the statutory laws, because decided cases are supposed to proceed from statutory laws. When you judge that judgment vis-a-vis the statutory laws upon which they are based, you will discover that that judgment is illogical, is contradictory, and does not reflect the position of the law in all its ramifications. There is no one issue that was treated by the learned justices of the Court of Appeal that was resolved in accordance with the law. And I say this intentionally. First and foremost, what destroys democracy is not corruption. It's not the incompetence of the leaders. It is not their dishonesty. It is the inability of the electoral bodies to conduct free, fair, credible, and periodic election. Democracy has not promised you that it will perpetually give you good leaders. Democracy has promised you that you would have a chance after a certain definite period to change your leaders if you don't want them, or to sustain them if you do want them. So what brings down democracy is the inability of the people to change their leaders or sustain them whenever they wish. Remembering that free, fair, credible, and periodic election is the main pillar of democracy, without which there can be no democracy. The reason you have queues in Africa now is not because of bad leadership. It's not because of corruption. It is because the people from that country have been denied of their rights, either through rigging of elections or through sectitism. In other words, no election in the first place. And when the people become frustrated, they will have no other choice than to employ force, because those who make peaceful change impossible makes violent change inevitable. So you see, that is why we are pleading. That is why we are preaching that we must ensure that in Nigeria we have free, fair, credible, and periodic election. That's the only thing that can sustain our democracy. Whether you talk about Gabon, whether you talk about Niger, whether you talk about Mali, whether you talk about Burkina Faso, whether you talk about Guinea, the reasons for the coup d'etat there are simple: sectitism and rigging of election. Even the Gabonese coup leader made it clear it was because the elections were rigged. That the man can rule a country for 50-something years is because there is either no election or elections are rigged. Having said that, coming back to Nigeria, We had election in Edo, we had election in Anambra, we had election in Ondo. Nobody questioned the results of Inec. Nobody went to court, strictly speaking, to challenge the results. In Edo, as tensed as the situation was, an incumbent that just defected from a party to another party won, and nobody took him to court because of the result, because it was credible. The results were uploaded on Inec result viewing portal like they promised. Everybody saw it. The only reason they went to court is to challenge the qualification of Basic, which was thrown out. Same thing in Anambra. The runner-up did not even bother going to court. The elections were credible, uploaded from polling units, transmitted electronically in real time. The whole world saw it, so you don't need to tell anybody who won the election. The people will be telling you who won the election. The same thing happened in Ondo. They did not go to court to challenge the result of Inec. They went to challenge that Bunu, who signed the form, was not supposed to. All these things failed. They had peace because the election was credible. Inec did what they promised. Electronic transmission of results was employed. BVAS was deployed, and results uploaded in real time from the polling units. And collation was done by verifying the manually collected result with the electronically transmitted result, and the public saw them and approved them. And that was what raised the confidence in the people that the election of 2023 was going to be free, fair, credible, and that everybody who partakes in it will come out satisfied. Unfortunately, on the 25th of February, Inec somersaulted in all the things they promised. Professor Yakubu Mahmoud and Festus Okoye, the mouthpiece that went around telling people, trust us, electronic transmission is mandatory, we will do it. Mahmoud even said he will have television on top of his head, and as he's reading the manually collated results, you'll be watching the electronically transmitted result. And you know what? That is what the law says. Electoral Act 60 subsection 5 is very clear that after the election you transfer to the collation system in a manner prescribed by Inec. And in paragraph 38 I of the Inec regulations and guidelines for the conduct of election, Inec was very clear. On completion of the polling units voting and the results procedure, the presiding officer shall electronically on the line transmit the polling unit results to the collation system and use the BVAS to upload the scanned copy of the form EC8A, that's the polling unit result, onto the IREF portal for the public to see. And Inec made it clear, following the dictates of Electoral Acts section 64 subsection 4AB. He said you should not collect, you should not announce the result except you verify the authenticity, that's the correctness of your manually generated result and the number of accredited results on from EC8A with the one transmitted in the collation system. And INEC was clear in paragraph 48, A and B, that you can only collate when those transmitted results are there for you to verify their correctness. Now, what it means is that the law has outlawed sole manual collation of results. So what you have now is you must verify the authenticity of the manually collated result with the electronically transmitted results. This is the position of the law. And INEC said in collation of the result, after every collation center, the collation officer must transmit to the collation system for the next collation center of the next level to use to verify. And I'm talking of paragraph 50XX, paragraph 50XI, paragraph 53XII, and paragraph 54XII of the INEC regulations and guidelines for the conduct of election. Each level, when you finish at the ward level, collation officer transmit to the collation system. That's what you call when you hear INEC server, when you hear database, when you hear National Electronic Register of Election Results, well, by whatever name you want to call it. The law says without BVAS, there is no election. Section 47. BVAS is simply the electronic device with which you use to accredit people through facial recognition or fingerprints, to store results and information, to transmit. Say without BVAS, there is no election. INEC made it clear in paragraph 38 III. When you finish, you take the manual results and the BVAS to the collation centers for the use of the collation officers. These are the position of the law. What did the Presidential Election Petition Court, what was their judgment? That transmission of election electronically is discretionary. So the court is telling INEC what the law is. It's not the duty of the court to make laws. Their duty is to interpret the laws. The laws are already made around the whole Nigeria, telling us the position of the law. And they gave us the paragraphs. They gave us the Electoral Act. And then the court is telling you another law. I don't know wherever they use the word discretionary. I don't know wherever they use the word may. Everything about section 60 subsection 5 is shall. Everything about section 64 subsection 4AB is shall. Everything about paragraph 38 I is shall. Everything about paragraph 48 AB is shall. Where did they get the discretion from? In any case, assuming without consuming, you, the court, said INEC has the discretion to determine the mode of transmission. And INEC has chosen, assuming INEC exercised the discretion to give themselves the law that mandates them to do it in a particular way. And you, the court, again is coming to say it's discretionary. Look at the contradiction. Assuming by their own judgment, transmission is discretionary. And then the court agreed. INEC said they would transmit electronically. The court agreed. INEC did not transmit electronically. And the court now came from nowhere and said it doesn't matter. So either way, the judgment is illogical. It does not flow from the law. And Supreme Court has made it clear. Oyetola and INEC, in other words, if you like, call it Oyetola and Adeleke, the Osun Guba election. He said, as the names depict, and I'm talking about page 24 of the lead judgment by Emmanuel Akomai, of the justice is the justice of the Supreme Court. He said, as the names depict, the collation system and the INEC results reviewing portal, that's IREV, are now part of the election process. He said, so the polling unit results transmitted to the collation system are now the means with which the collation officer verifies the polling unit results for the purpose of collation as the need arises. This is Supreme Court judgment. And I said page 24 of the lead judgment by Honorable Justice Emmanuel Akomai, Justice of the Supreme Court, JSC. I wonder why the court was citing the judgment of Federal High Court to compare it, to subordinate it with the judgment of the Supreme Court. Here the Supreme Court again. The polling unit results transmitted. Use the word transmitted. Do you transmit something manually? Transmitted to the collation system is now the means with which the collation officer verifies the polling unit results for purpose of collation as the need arises. That's all. That has secured our Electoral Act 2022. Yet, the PEPC, in their own judgment, said it's discretionary. Then what do you use to verify the manually collated result? Then what is the essence of Electoral Act 2022? Because that is the whole essence. Recall that when they were enacting this law, they left out the issue of electronic transmission of result, and the whole Nigerians rejected it. President Buhari rejected it. They had to go back to put it. And recall, the reason they did not mention the specific card reader is they said, look, if we mention any specific type, when technology increases and advances, and that one is obsolete, INEC will now need to amend the law. So let us leave it to the discretion of INEC, so that they wouldn't need to come back to us to amend the law. They would just deploy the new technology. So the discretion on INEC is not as to transmitting and transferring electronically. That is settled. It is as to the electronic device that you use. BVAS, for instance, was an improvement to our first card reader. So the INEC needed not to go back to the National Assembly if they want to change BVAS to another updated electronic device. That is the discretion the law gave to them, not the discretion on whether they will transmit electronically. In any case, would you approve about electronic machine if there is no electronic transmission? What are you doing with it? Isn't it funny? If there is no electronic transmission result, what are you doing with the electronic device? What are you doing with card reader? Are you using card reader to do the accreditation? If you don't have any use for the accredited results, you're using electronic device to store information and transmit. So if the law says no BVAS, no election, in other words, no card reader, no election, the law is simply saying no electronic storage and transmission of results, no election. So any act done that is not in accordance with this election process is void ab initio. There was no election. So it's unfortunate that the presidential election petition court went against the law in the issue of non-compliance. And that non-compliance was fundamental because it was a breach of the election process. What it means is that the unverified, manually collated result by Inec is not credible and should not be allowed to stand. Let me give you an example. Till today, Inec has not produced polling unit by polling unit results as demanded by law, section 62, subsection 2 and 3 of the Electoral Act. He said Inec should update the electronic register, polling unit by polling unit, and at the end of the day, anybody that wants a copy should be given the copy. Till today, it's not available anywhere. Like I gave you example, if you go to Edo, Anambra, Ondo, you still see the results uploaded. Not so with the 25th February presidential election. So I want to tell you that till today, there is no election known by law that took place. And INEC has not shown anybody. I read mathematics. When I was in school, if they give you a question in mathematics and you just quote the answer, you will fail. They will even accuse you that you copied. The statement on how you arrive to the answer is more important than the answer you give. And it's those statements that gives you marks. INEC just came from nowhere and quoted an answer. No statement on how they arrived at it. And yet the courts say it doesn't matter. The courts murdered justice. And justice is crying. And I pray that justice does not revenge on Nigeria. Now, the other issue the court said is about non-qualification of the presidential candidate of APC owing to 1, invalid nomination, 2, double nomination. Ironically, the court said it's an internal affair of another political party. And so no candidate has locus stand to inquire about it. With profound respect, that is not the position of the law. Internal affair of a political party relates to litigation arising from their primary election. When a party wants to nominate a candidate, they embark on primary election. How they organize their primary election and came to their candidates is their internal affair. That is what is called pre-election matter. We're not even talking about nomination of candidates, strictly speaking, because APC has finished nominating its candidate. We're not even talking about nomination of the vice presidential candidate, because APC had finished nominating its vice presidential candidate. You remember the placeholder? Good. So in the eyes of the law, they had completed the nomination of their president, presidential candidate, and even vice presidential candidate. Meanwhile, it is not the party that nominates the vice president. It's the presidential candidate. So that is outside the primary election of a political party. There is no aspirant vice presidential candidate anywhere. And in election matters, it is only the candidate that participated in the election or the political party that has the locus to challenge whatever action that took place. So no aspirant of a political party can challenge the nomination of the vice presidential candidate, because it is not the duty of the party and he does not arise or emerge from the primary of a political party. It's a constitutional issue, which is the duty of the presidential candidate only. And the only election the vice presidential candidate goes into is the general election. So it is only the participants in the general election or the party that participated that has the locus to challenge any irregularity in the nomination of the vice presidential candidate. To hold otherwise is to say that whatever anybody does about the vice president, nobody can challenge it. And that's not the position of the law. Now, secondly, in this particular case, because before you apply judicial precedent, the facts must be on all fours. This is the first time in our electoral history that we are using the issue of placeholder. So the facts of this case is different from the facts of the earlier cases. It has never happened. So the presidential candidate of APC, when the first candidate withdrew, had 14 days by law to change his vice. He did not. The political party had 14 days by law to submit a replacement. They did not. Immediately the 14th day struck and they did not. Their nomination was null and void, invalid. So from that day on, APC did not have a presidential candidate or a vice presidential candidate. So they practically entered the election without a candidate. And then the party, especially APM, came and said there was invalid nomination. In other words, there was no nomination at all, which is exactly in accordance with the law. If you read section 31, section 33 of the Electoral Act. Now, that's about invalid nomination. So APC went into that election not having any candidates. And the position of the Constitution, one of the qualifications is that you must be sponsored by a political party and you must be a member of the party. And APC did not sponsor any candidate for the presidential election. And the only people that have the locus to sue are the candidates that participated in the election. So, Labour Party, PDP, APM, they have the locus standing to sue. Yet, the PEPC, I don't know where they got their own law from, said they didn't have the locus standing. My question is then, who has? If they don't, who has? Because no aspirant has the locus standing to sue on the issue of vice president. The vice presidential issue did not emerge from primary of a political party. The vice presidential issue is not a pre-election matter. As a matter of fact, you have 14 days to bring up pre-election issue after the primary election. The presidential candidate has till 90 days before the election to choose. So if you say the issue of vice presidential nomination is a pre-election matter, it would have even, the time for you to go to court would have even been gone before he is appointed. So you see, it is not based on the law. This is law. This is logic. This is clear thought. The issue of double nomination, look at the logicality of what they say. They say there was a letter written 6th July by the candidate to his party. And that means there is no intention. He had no intention to go into double nomination. Meanwhile, it was on the 10th of July that the presidential candidate of APC mentioned the first time in Daura that he has chosen his vice presidential candidate. And he said it openly that the man is not aware. How could he have written a letter 6th of July? when he became aware that he will be vice presidential candidate 10th of July. What kind of logic is that? Because as a court, you have to evaluate evidence and put it in sequence. Anyone that contradicts objective reality cannot be true. You know what lawyers do. Meanwhile, they said any communication by a party with its member is an internal affair of the party. We're talking about nomination. They said if the candidate writes to his party, the party will convert to Inec. If the party has not converted to Inec, we have no business to interfere in the internal affairs of political party. And now you, the court, you're using the internal correspondent of a political party, which you cannot verify, especially placed side by side with the objective reality that the presidential candidate said it was on the 10th of July that he made a decision and that he was not aware of it. And you're using the same correspondence to say that he had withdrawn.
Thank you very much.
That is why I said the judgment is illogical, it is contradictory, and it's not based on the law. There's still another issue of striking out the subpoenaed witnesses. A party presented 13 witnesses, and you say you're striking out 10 witnesses and all their evidence. And your reason is that they are subpoenaed, that their witness statement on oath was brought outside 21 days. You know why it is laughable? Subpoena is the order of the court. So the court is telling you their own order is irrelevant. What the law says is that it is only the petition that is unamendable, and it is only the petition that must be filed within 21 days. The petition is different from the witness statement on oath. The petition contains the facts. You're not even supposed to give evidence or start citing laws in the petition. It contains the facts that you want to rely on. The witness statement on oath is the evidence that you use to prove those facts. Now, when you are bringing witnesses, you yourself bringing witnesses, and the evidence that are available in your hand, the law says they will accompany the petition. If they are the same thing, the law will not say they will accompany. Good. But the law says evidence or further particulars can also be given about those facts that you have deposed to in the petition. And the witnesses that were not available to you are the ones that you subpoena, or the witnesses that are adverse to your case, who will not willingly come to testify in your favor, are the ones you subpoena. There is no place in the law that says that subpoena witnesses are not allowed to testify.
Yes, sir. Is that not the reason why there is a...
As a matter of fact,
yes,
there are places in the law where they say it should be admitted. Paragraph 5 is there. Paragraph 14, 2II is there. Paragraph of the election, the procedure for election, which is the schedule, according to the Electoral Act, Schedule 1. Now, paragraph 54 said the Federal High Court rules should guide the election procedure. wherever there is no rule. And the rule of the federal court is very clear that subpoena witnesses can be brought in even after the trial has commenced. In any case, the court cannot even issue order except the trial has commenced. Assuming that you want to bring Inec to testify for you, do you think Inec will willingly come to testify that they are criminals? Is it not when the trial commences that you will now seek for the order of the court? Then for the court to order Inec to come and testify, we issued a lot of subpoena for Inec. They refused to come to testify. The court did nothing. And the court was very quick in saying, we did not prove our case. If Inec says the original of Form EC8A, they don't have it, it's not in existence. If there is no uploaded electronic resource, you pulling in it by pulling it, as required by law, that Inec must comply, and they refuse to give it to us, then you're asking us to produce it in court. Is that not illogical? The person that organized the election told you it's not existing anywhere. And again, they keep talking about the issue about parties should have a duplicate. Who told you that it's mandatory for any party to have agents in 176,000 units? The law recognizes that there might be some parties that might not be able, so there's no place it is compulsory. It is not the political parties that organize election. Labour Party, for instance, we made it clear. Eventually, it was 133,000 something polling units. But we didn't have any need to worry because the INEC has already said they will upload the result in real time from the polling unit. We don't want to be a corrupt political party. We were doing things according to how we would do it. We're not getting sponsorship from corrupt people. 18,088 polling units results were blank, blood, presented, collected from INEC. And you're saying it doesn't matter? We should provide our own, not counterparts, duplicates. Most of them are not even clear. You know, when you write something and you put your carbonated sheet, when it gets to that ground, it might not even be clear. You, the courts, you're telling political parties you did not prove, and you couldn't tell the organization that is mandated by law to present those documents before you, and you couldn't enforce them. What kind of justice is that? Let me tell you, Electoral Act 2022 has made proving electoral case very clear, very straightforward. We can do it in 60 days. The problem we have now is the judiciary. You know what Section 137 of the Electoral Act said? He said if you can produce all the documents, the originals and CTCs of the documents you need to prove your case, you don't need to bring one witness to testify. You don't need to bring one. In other words, if INEC should fulfill the law and provide the documents which was uploaded from the polling unit to all the parties, you don't need one witness. But look at what the court is saying. The same court that said 21 days we must produce all witnesses, all their witness statement on oath, the petition say we must bring 176,000 witnesses to prove our case. Because they say it is polling unit by polling unit. The politicians who are members of the legislature knew that it was impossible when they put that law. Yeah, because they know you can't dump a document on the court. Who told you it's dumping? Excuse me, let me tell you, election petition is sui generis of its own kind. They recognize there is limitation to time. They recognize that there is limitation to space, and they made laws to accommodate it. If the law says if documents original and the CTC proves your case, you don't need oral testimony from any witness. That is what the law says. Don't add to it, because the first canon of interpretation is that when the wordings of a statute is clear and unambiguous, the court is under compulsion to give it its ordinary meaning. Proving electoral cases is now simple and easy. The only problem we have now is the judiciary. You can imagine telling PDP when they brought all the documents that no, it's dumping. No, it is not dumping. Once it is CTC of documents of Inec, is enough to prove your case. Otherwise, let us forget the issue about election petition, especially the presidential election, because it will be unprovable. So the striking out of the subpoena witnesses and the evidence is not in accordance with the law. Paragraph 5 is very clear. Evidence and further particulars are still admissible. Paragraph 14, 2II. You can bring in the position even after the commencement of the trial. But you cannot bring in the position, and I want you to underline this so that you don't confuse what I'm saying, to begin to prove on facts that you did not aver in your petition. Get the point? The petition is unamendable, and I agree with it. Once you have deposed, once you have averred to all the facts in your petition, what the law is saying is that if evidence is gotten even after the trial, witness statement on oath is evidence, you are allowed to bring it in if they are subpoena witnesses. Not that you will come and under the subpoena witnesses to begin to bring about evidence which you did not depose to or which you did not aver in your petition. If the facts are not there, you cannot bring a subpoena witness or any deposition on oath to come to say you want to prove it. So it's very important you make that clarification, because I saw some citation, some cases which the court was trying to cite and which they did not distinguish. In such cases, in some of them, the petitioners did not place the facts and averment in their petition, and they now came the way of purported subpoena witness to begin to amend the petition. That's what it means. But when you have averred to those facts, you are not trying to amend the petition. You're trying to substantiate it. These are two different things. Good. So my position is that if you did not make the averment, if you did not plead them, in your petition, you don't have the right to bring subpoena witnesses after 21 days. But once you have pleaded them, once you have averred those facts completely in your petition, you should be allowed in the process of trial to bring your evidence to prove them. Otherwise, it will not be provable. Because what Inec just needs to do, or any witness that's a rival witness to you, which you need his evidence to succeed, is to hide himself for 21 days. And that's the end of your case. That couldn't have been the intention of the legislature. So the totality of the judgment is not a judgment that delivered justice. It was not decided based on law or logic or clear thought. If the judgment of the PEPC is sustained, Electoral Act 2022 is dead.
Thank you very much, sir. Well said. Really, in a few days, lots of people are still very doubtful about the way the judiciary is being handled. What would you say about this going forward, sir?
You know, they used to say judiciary is the hope of the common man. I don't blame the people that made that philosophy, because if you are from a country governed by military for a long time, where some people are above the law, because the military clique and their cabal is above the law. That's where they brought that philosophy that the judiciary is the hope and the last hope of the common man. But the truth is that in a democracy, where rule of law is one of the pillars of democracy, the judiciary is the hope of everybody, common and uncommon. You have seen great people removed in power illegally. Do you see common people, in quote, contesting for governorship? But you have seen people go to court to reclaim their mandate. So judiciary is the hope of everybody in a democracy. And more importantly, judiciary is the last hope for the sustenance of democracy itself. If elites do not write justice on black and white, ignorant men will write it on ground with blood. If the judiciary do not write justice on black and white, ignorant men will write justice on the ground with blood. It's not my quote. So we should be very careful. Very, very careful. So when people are going to judiciary, it is to make sure that the peaceful transfer of power, as ensured by democracy, which is government of the people, by the people, for the people, is ensured. They should be careful the way they deliver judgment. It is not the duty of the judiciary to make the law. The legislature can overrule decided case by simply amending the law. The judiciary cannot overrule a legislation. They can only review it to know whether it contradicts another legislation. Meaning, the only reason the court can interfere with a piece of law is to know whether the legislature has done a law that contradicts its own law. So the court has no business, except where there is a lacuna, no law. Then they can now come in under the overarching principle of wherever there is law, there must be remedy, to put a remedy. Using your discretion to give technical judgments is illegal in itself, and the Supreme Court in itself has said the court has no jurisdiction to use its discretion to overrule the express provisions of a statute. So, as we are going into 63 years, I am pleading with the judiciary. They should be careful, because when we do not have strong institutions, we could still have strong individuals that want to manipulate the institutions for their own selfish ends. And the only protection that the system will have is the judiciary. So as we're getting to 63 is getting to grandfather. Nigeria is getting to grandfather level. We should be able to have children, grandchildren, that reflect what we want our nation to be. We are taking too long to mature. At 63, we are still drinking milk. We have not grown in anything. We discovered oil 58, even before independence. And we are importing 100% of our refined crude. Not even a baby country that has oil can afford to be doing that. Our naira is going to 1,000. Going to 1,000 to $1. And 1,000 plus to the pounds. And when we got independence, our naira was stronger than the pound. So we are actually degenerating. And not in our stars, but in ourselves. We are the most blessed country in the whole world. We have our gold. We have our lithium. We have our iron. We have our tin. We have our coal growing like carrots. Foreign countries are coming to mine it under our nose. We have our oil flowing like a river. We have our cattle to give us milk. A land flowing with oil and milk. 850 kilometers of coastal line. We can survive on blue economy alone. We can survive on solid mineral alone. We can survive on oil alone. Can you imagine if we are refining our diesel, kerosene, jet fuel, condensate, all the things, and we are exporting them. With exporting our crude, we can survive on them alone. And yet you have the combination of all these things. And should we not say that we have cursed leaders, that we have all these things, and we are wallowing in poverty? And out of 200 million persons, 133.3 are suffering from multidimensional poverty. We are depraved and deprived. We can't go through our streets without being afraid that we will be kidnapped, terrorized, or robbed. We cannot embark on nightlife. In the southeast, we have the unknown gunmen killing at will. In the south, we have the oil thieves. In the southwest, you have the cultists and ritualists. In the north central, you have the killer headsmen and terrorists. In the northwest, you have the bandits, terrorists and kidnappers. In the northeast, you have the insurgents, IDPs. And we have what it takes to put an end to this. And as we're moving to 63, if the judiciary can live up to its expectation today, we will not have all these cases we are having in courts. You know, the Chief Justice of Nigeria said Nigeria is the most litigious nation on earth. You know why? Because the judiciary is not living up to its bidding. If every lawyer knows that if he brings this case to court, this must be the judgment, even the clients will not go to court. But everybody's going to court because they believe they can have a judge they can influence to give them judgment that they want. That's the truth. Why don't they go to courts abroad? They will tell you what the courts will say, and that's what the court will say, because the court will determine according to law. So if the Chief Justice of Nigeria does not want Nigerians to be the most litigious people on earth, let him just do one thing. Any judge that does not give judgment based on the law should be sanctioned. Can you imagine in the tribunals throughout, you can see the contradictory judgments. In Plateau State alone, tribunals were giving contradictory judgments, removing some people, returning some people on the same issue about whether PDP has structure or not. So if the Chief Justice of Nigeria wants Nigerians today not to be the most litigious people on earth, it's easy. Any judge that does not rule according to law should be sanctioned. Simple. You will see all the judges now sit up. You will see many people, they won't go to court. Quote me. I am a lawyer. And I know what my clients, what they feel. So what I do, because I know I don't go to any judge at all, whatsoever. Anybody that's telling you that all our judges are corrupt is not telling you the truth. Because I'm a lawyer. I've won most of my cases and I have never visited any judge. Tell your clients the truth. This case cannot go. This case can go. The most place we have problem is in political issues, because you have political interference. And then a lot of judges who cannot sustain or is strong enough to withstand the political pressure, cave in.